thing about Juan Galt. He's not a troll. He's a well thought out, and most of his responses are well thought out.
Oh, Mark, those were the good old days. Today, I'd have to put you down as a maybe. But I don't know why you get so upset with me. I'm just telling the truth. But sometimes when you criticize people, you start taking flack. Huh, I must be over the target. Now, there's a listener that evidently, Misty, who supplied some court cases to Mark that evidently she copied and pasted from my YouTube video channel. And these cases were about who can make a legal conclusion. And some of these parties to these lawsuits thought that an expert witness could render a legal conclusion. But as you can see here, this is kind of the opening slide of Mark's latest video. He says that listener Misty is arguing the courts have ruled that cops cannot testify to the applicability of the laws. As support, she cites cases dealing with expert witnesses, not cops. Well, Stevens totally misses what these cases prove. These cases prove beyond a reasonable doubt that only a judge can make a legal conclusion whether the laws apply. Not even an expert witnesses or cops can make a legal conclusion. So who can make a legal conclusion? Well, here these definitions come from all over the interweb. I guess Stevens could Google conclusion of law. These don't come from Wikipedia, Stevens' favorite law source, but Wikipedia does agree with this. A conclusion of law is a judge's final decision on a question of law, which has been raised in a trial or a court hearing, particularly those issues which are vital to reaching a judgment. These may be presented orally by the judge in open court. That would be like when he overrules an objection or he denies a motion. It's also the rule by which rights of parties in lawsuits are determined by who? By a judge's application of relevant statutes or legal principles. In other words, the applicability of law. A conclusion of law is a determination by a judge or ruling authority regarding the law that applies in a particular case. It's all questions of law arising before, during, and sometimes after a trial that are to be determined solely by the judge and not by the jury. Now, where does it say that someone other than a judge, like a cop, if Stevens, that's what he thinks, can make a conclusion, a legal conclusion? Nowhere. You won't find that anywhere. Now, these are referred to the court cases that Stevens says aren't applicable to a cop, and because they only involve expert witnesses. But, like I said, Stevens misses the whole point of these cases cited. But for him, that's normal. Now, as was my plan, I kind of suspected this would happen, but Stevens grabbed onto the term expert and automatically claimed these cases were not applicable to whether a cop can make a legal conclusion about applicability. Stupid internet lawyer mistake. There are two types of witnesses, lay and expert, and neither can make a legal conclusion. I noticed Stevens left out the part where the court in Turupchek refers to cases that establish no witnesses can make a legal conclusion about applicability. Only a judge can decide the applicability of the law, to wit, quote, in no instance can a witness be permitted to define the law of the case. And there's quotes, and there's plenty more cases that support that. Now see where it says in no instance? That means not only a cop, but even an expert witness is prohibited from testifying about the applicability of the law. That requires a legal conclusion. So where's Stephen's cases that say a lay witness like a cop can make a legal conclusion? Where's evidence that says that? It doesn't exist. Now, I could have probably started with these cases, but I wanted to see if Stevens would fall for my trap, and of course he did, like any ignorant internet lawyer did. But here's proof that a cop is prohibited from making a legal conclusion. It has nothing to do with expert witnesses, just a regular lay witness like a cop. In United States versus Griffin, the court found that allowing Steiner, or Steiner, I don't know what her name is, a lay witness to testify to her own interpretation of the law was error. The court said, quote, Steiner testified on behalf of the government as its first witness. Notably, she was never qualified as an expert witness. Although Steiner was not qualified as an expert in law, she was permitted to give opinion testimony as a lay witness under Rule 701 of the Federal Rules of Evidence. Of course, the government cannot, in this manner, be permitted to substitute its witness for the court as to the applicable law. And the court's quoting out of Wigmore on evidence. Nor was the witness's opinion and conclusion admissible as to one of the ultimate facts to be decided by the jury. There are the other court cases, and there's many of cases that establish that even a lay witness, nobody but a judge can make a legal conclusion. Now, let's look at Rule 701 that was referred to in that case. Now, here's what Rule 701, which is the rule on opinion testimony by lay witnesses. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact in issue, and C, it cannot be based on scientific, technical, or other specialized knowledge within the scope of Rule 702, which is the rule governing expert witnesses. So point A is the empirical evidence from the 5 senses that the cop experiences. Point B would come into play if you asked the cop, why do you believe the law applies? He could answer, from my training. But if you ask the cop for evidence that the laws apply, that goes to applicability and calls for a legal conclusion. And legal conclusions are the exclusive province of the judge. Period. Full stop. That's it. Now, you people can choose what kind of legal information you want to believe. But I love this slide.
Go home, folks.